to a fresh episode of Legal Wrangle on international taxation. We have selected 4 important cases, including the one which may take you down the memory lane, and it is about one of the least known tax havens in Europe. That is Liechtenstein, a rich 160 square kilometer landlocked country perched on a barren mountainside between Switzerland and Austria. About 80 years ago, it was known as Island of Penury in Europe, but it is now one of the vibrant financial centers in Europe. And it gained notoriety after sensitive data from its main bank, LGT Bank, was leaked to Germany, and some of the names in the list of account holders were Indians. One such case was recently decided by the Mumbai bench of the ITAT. Let's begin with the case. The assessees are individuals. The assessing officer received information that the assessees were beneficiary of Marnishi Trust, having account in LGT Bank, Liechtenstein. The information received also gave summary of the bank statement of the trust, in which the opening balance was more than 3 lakh US dollar and the accrued interest was 84 US dollar. Since the information was not disclosed by the assessees in their income tax returns, the assessment was reopened. The assessee in response denied knowledge of any such trust. Subsequently, the AO issued show cause notice giving details of the bank account deposits and interest earned. In response, the assessee again denied any knowledge of the said trust, but the AO made certain additions.
On appeal, the CIT appeal ruled in favor of the revenue. On further appeal, the tribunal held that, firstly, if the AO has furnished all the details received through tax evasion petition with the assessee, but the assessee did not avail the opportunity to deny charges, the assessee cannot now question the reassessment order. Secondly, when it is common knowledge that discretionary trusts are created for benefit of a particular person, and such person may not have control over its affairs, even then the deposits made in such foreign bank account are to be treated as undisclosed income in the hand of the sole beneficiary. Thirdly, mere fact that the data relied upon by the revenue was stolen from a bank in a known tax haven does not adversely impact the veracity of the information. And lastly, when the revenue has provided all the documents, the onus shifts on the assessee to prove that it has no beneficial interest in the said bank account.
Thus, the ruling went against the assessees. Let's now move to our second case. The assessee company is engaged in manufacturing of electric motors, transformers, gearless machines for elevators and maintenance of its products. During the pertinent year, it made an application to the AO to allow it to remit 14,000 US dollar to Inherent Simplicity Limited, Israel, without deduction of tax. In its letter, the assessee mentioned that it had subscribed a software from the Israeli company on annual user basis, and the subscription price was 34,000 US dollar for the first year, including one-time on-site installation and training support for 3 days. The assessee was required to pay annual subscription fee of 14,000 US dollar. The Israeli company had no PE in India. Since the software was allowed to be used without any right to exploit the copyright, the proposed payment did not fall within the ambit of royalty as per Article 12 of the India-Israel DTAA.
The AO passed the order under Section 195, Clause 2, holding that a right was conferred on the assessee to use the copyright and also to copy it for the use of its business purposes. Since the right to use the copyright was given, such payment is nothing but royalty, and directed the assessee to deduct 10% of TDS. The first appeal went against the assessee.
On further appeal, the tribunal held that once the assessee has opted to avail the benefits of the DTAA, there was no valid ground for the AO to invoke the provisions of royalty under Section 916. Secondly, no amendment under IT Act will influence the definition of royalty as given under respective DTAs, and the verdict went in favor of the SSE. Let's now move to our third case.
The SSE company is engaged in the development of international trade and is also procuring raw materials and marketing finished products in India through various Indian joint ventures of Mitsubishi Corporation in Japan. During the relevant year, a survey was conducted on the license office of the Japanese company, which finally conceded that it was liable to pay tax in India. On the basis of the SSE's letter to the department, the AO inferred that the SSE had admitted the existence of its PE in India. Thus, the AO took the view that all the provisions of TDS were applicable to it and all payments made to non-residents were liable to TDS under Section 195.
When the issue came before the ITAT, the tribunal described the company as Sogo Shosha and held that since the payment made to non-resident company which had no PE in India, no TDS obligation arose out of such transactions.
The High Court finally held that, firstly, a comparison between the Income Tax Act and the DTAA can be made as regards the beneficial provisions even if there are no provisions parallel to Section 40AI of the IT Act in the DTAA. Secondly, an Indian entity was entitled till assessment year 2006 to 2007 to rely on the DTAA provisions to claim deduction of the sums paid to entities in Japan and the USA, since Section 40AI as it stood then continued to discriminate between resident, non-resident and was inconsistent with Article 24(3) of the India-Japan DTAA or Article 26(3) of the India-USA DTAA. Thirdly, obligation under Section 195 to deduct tax at source on payments made to non-residents cannot be forced upon SSE if the payment in question itself is not chargeable to tax. Lastly, explanation 2 to Section 195(1) will not compel deduction of TDS where the payer is reasonably certain that the sum paid for purchases is not chargeable to tax, and the verdict favored the SSE. Now let's go to our last case.
The assessee individual is an NRI. On examination of his return, the AO observed that assessee had offered the long-term capital gains at the rate of 10% in place of 20%. On inquiry, the assessee explained that the shares of Messrs. Applabs Technologies Private Limited were brought with the convertible foreign exchange and hence they were foreign exchange assets and therefore the assessee was eligible for the concessional rate as per Section 115E. The AO observed that the assessee was allotted bonus shares against the original shares bought by him and that some other shares were given to him by overseas investors without any payment from him.
The AO further observed by August 2007, the SSE had already sold all the original shares which were bought by him in convertible foreign exchange and the shares which were sold in September 2011 were the bonus shares and the shares acquired by him free of cost from overseas investors. Since none of the shares sold were purchased in foreign currency, the AO was of the opinion that the SSE was not eligible for concessional rate under Section 115E. The AO observed that the SSE was allotted bonus shares in order to avoid tax as the management of the company was in hands of the SSE and his family only. He also observed that the SSE's father, who was a resident of India, had transferred some of the shares to his grandson and daughter-in-law, who thereafter sold their shares to claim benefit under Section 115E, thereby defeating the purpose of giving concession to NRI.
On appeal, the tribunal held that bonus shares can be treated as foreign exchange assets under Section 115E if the NRI SSE has not claimed any cost of acquisition while computing the long-term capital gain from sale of bonus shares. If original shares were initially acquired by overseas investors by way of inward remittances of foreign exchange, then the cost of its acquisition cannot be taken at nil. Since shares sold by NRI are treated as long-term capital assets, and the same falls within definition of foreign exchange asset, the NRI is eligible for a concessional rate, and the verdict favors the NRI SSC. With this, we wrap up this episode of Legal Wrangle. Keep watching TIOL Tube for our programs on topical issues. Thanks for watching.